in recent years, there has been a small group of people who attempt to mislead the public with misinformation on drug traffickers and the death penalty. They seek to evoke sympathy by presenting an image of an unfair criminal justice system stacked against drug traffickers. They publish videos, pictures, stories from the traffickers' childhood, sharing interviews with family members, and portraying the trafficker as a victim of unfortunate circumstances. But they leave out the facts of the cases. They leave out the accounting of the harms caused to the victims of the traffickers. They glorify the trafficker. They do not give any voice to the victims, the number of lives lost or wrecked by drugs, and the reason the traffickers were trafficking the drugs in the first place, which is to make money. If you face financial difficulties, if you need money, get a job. You don't have to traffic in drugs to make money. A 2020 study by the Ministry of Social and Family Development found that children whose parents had committed drug offenses were 5 times more likely than other children to unfortunately come into contact with the criminal justice system in the future. But these facts and images are usually missing from the speeches, posts of those who campaign against the death penalty. Instead, there are baseless allegations, one-sided claims, and half-truths. These baseless allegations are also made in relation to prisoners awaiting capital punishment. I'll call them PACPs. They cast doubt on the process, the legal process. They cast doubt on the convictions and the sentences. As a result of many such applications today, we have PACPs whose sentences have not been carried out, despite their cases being decided more than a decade ago. So to deal better with this situation, to deal better with unmeritorious applications being filed at the very last minute before capital punishment is carried out, this House passed an act, the Post-Appeal Applications in Capital Cases Act, PACC. That act will come into force very soon, within a few weeks. The act will seek to safeguard the administration of justice and the rule of law. It introduces new requirements to reduce potential delays to proceedings. For example, if the PACP had already had his or her sentence upheld by the Court of Appeal, then he or she will be required to apply for permission to make a PACC application. There will be a streamlined procedure under which only the Court of Appeal may hear PACC applications and grant a stay of execution. As part of the application, the person will be required to state the grounds of the application and the reasons for not filing the application earlier. But even before the law has come into force, a post-appeal application was filed by 36 PACPs in September last year to challenge the constitutionality of that law. The application was dismissed by the Court of Appeal recently. The Court of Appeal said the PACPs had no standing to bring such a challenge, and the fact that such a challenge has been brought at all spoke only to the PACP's abuse of the process of the courts. Just one day after the appeal was dismissed by the courts, 36 PACPs, of whom 34 were the same parties involved in earlier post-appeal application, filed another post-appeal application relying now on some other matter. This is not the first time large groups of PACPs have jointly filed applications to the court after all avenues of appeal and clemency have been exhausted. In the past few years, there were at least 5 other such jointly filed applications, each involving more than 10 PACPs. The PACC Act, when it comes into force, will deal with many such applications.